The Gentiles/heathen have implemented controls in the form of their rule of law to govern their form of what they call democracy, which is actually a republic. Their rule of law is not applied with equity and is quite obviously in deference to themselves. What follows is a Forbes.com article wherein a Gentile/heathen reporter admits the unjust nature of qualified immunity that protects law enforcement from personal liability in lawsuits resulting from their own prejudiced, biased, actions in their conduct and performance in law enforcement. In the most dire of cases resulting in multitudes of deaths in unarmed encounters, they have become judge, jury, and executioner with no repercussions for their actions. The outcomes of these types of encounters would be extremely different if law enforcement personnel faced personal litigation and resulting accountability, in the form of a prison sentence and financial accountability for their actions that have resulted in the death of unarmed or otherwise non-threatening encounters with fellow residents. Forbes.com. October 20, 2021. Supreme Court defends qualified immunity in police shooting, excessive force cases. Nick Sibilla, Senior Contributor, Policy. I cover criminal justice, entrepreneurship, and offbeat lawsuits. Without any oral arguments, briefing on the merits, or written dissents, the U.S. Supreme Court on Monday overturned two lower court decisions that denied qualified immunity for police officers accused of deploying excessive force in California and Oklahoma. First created by the High Court nearly 40 years ago, qualified immunity is a legal shield that protects law enforcement officers, as well as other government employees, from being sued for violating a person's constitutional rights, unless those rights were clearly established. Worse, victims of government abuse face a vicious catch-22. The law must be clearly established for an officer to be denied qualified immunity, yet courts can grant qualified immunity without ever deciding if the right exists, thus not making it clearly established. In its twin unsigned rulings, the Supreme Court re-emphasized that cases involving split-second decisions must include almost identical facts and strongly suggested it could make overcoming qualified immunity in those types of excessive force cases even more difficult. The first of Monday's decisions sprang from a 9/11 call in Union City, California. Barricaded inside a room and with no way to escape the house, a 12-year-old girl warned the emergency dispatcher that she, her older sister, and her mother were in danger because her mother's boyfriend, Ramon Cortez Luna, wanted to hurt them and was trying to break into the barricaded room, reportedly with a chainsaw. Police responded, arrived on the scene, and identified Cortez Luna inside the home, carrying a large metal tool. Officers ordered him to drop it and to come outside with his hands up. Cortez Luna began to comply, dropping what he was carrying, and walked outside. About 10 to 11 feet away from the officers, he was told to get on his knees. Suddenly, one of the officers saw a knife sticking out of Cortez Luna's left pants pocket. Cortez Luna then dropped both his hands and his head and turned to face that officer. Cortez Luna was immediately hit with 2 beanbag rounds from a shotgun and ordered to get down. As he began to lower himself, another officer quickly pushed Cortez Luna down to the ground with his foot and pressed his knee into Cortez Luna's back, before pulling the arms behind the back, ready to be handcuffed. In response, Cortez Luna filed a federal lawsuit against the officers, claiming the officers used excessive force, which in turn caused him to suffer from ongoing neck and back pain, headaches, and emotional distress. A district court ruled that police were entitled to qualified immunity, though Cortez Luna found better success on appeal. Although the Ninth Circuit U.S. Court of Appeals held that deploying the beanbag shotgun was objectively reasonable under the circumstances, it declared that kneeling on Cortez Luna's back was excessive. At that point, the objective situation altered dramatically and Cortez Luna no longer posed a risk. He was lying face down on the ground, experiencing visible pain from having been shot by the 2 beanbag rounds, and not resisting. The Ninth Circuit further cited a decision from 2000 to show that it was already clearly established that an officer pushing his knee into the back of a prone, unresisting, injured person violates the Fourth Amendment. However, the Supreme Court declared that those 2 cases were not sufficiently similar. The facts of this case were materially distinguishable from the precedents cited. Neither Cortes Luna nor the Court of Appeals identified any Supreme Court case that addresses facts like the ones at issue here, the High Court noted. And even assuming that circuit precedent can clearly establish law, the officer who kneeled on Cortes Luna's back would still be entitled to qualified immunity. Note, this is another incident of a law enforcement personnel's knee on the backside of someone to subdue them, after compliance to verbal orders from law enforcement, thankfully, this one not resulting in a death encounter. How many more have gone unreported before or after the Ferguson, Missouri case? In other words, only decisions by the Supreme Court and not decisions from a circuit's appellate court could be valid for qualified immunity. Since the Supreme Court decides so few cases, adopting this requirement would substantially narrow the number of clearly established rights, further bolstering qualified immunity's power as a legal shield. But in its second decision handed down on Monday, the Supreme Court had already perpetuated another catch-22 for qualified immunity when it reversed a 10th Circuit decision that rejected qualified immunity for officers who shot and killed a man holding a hammer. We need not, and do not, decide whether the officers violated the Fourth Amendment in the first place, or whether recklessly creating a situation that requires deadly force can itself violate the Fourth Amendment, the High Court asserted. After he showed up drunk and entered his ex-wife's garage in Tahlequah, Oklahoma, Dominic Rollis was confronted by several police officers, one of whom asked to pat Rollis down for weapons. He refused. Officers then began to step closer, spurring Rollis to retreat to the back of the garage, where he grabbed a hammer. In response, officers drew their weapons and ordered Rollis to drop the hammer. He didn't. Instead, Rollis raised his hammer high. Sensing a threat, two officers fired multiple shots, killing Rollis. The full encounter, the 10th Circuit noted, from the request to frisk to Dominic's collapse on the floor, took less than a minute. In a unanimous ruling, the 10th Circuit held that it was clearly established that cornering Dominic in the garage might recklessly or deliberately escalate the situation, such that an officer's ultimate use of deadly force would be unconstitutional. But for the Supreme Court, this was much too general to bear on whether the officer's particular conduct here violated the Fourth Amendment, and once again insisted that clearly established law can't be defined at too high a level of generality. According to the High Court, the 10th Circuit relied on cases that were dramatically different from Rollis'. For instance, one cited case involved officers responding to a potential suicide call by sprinting toward a parked car, screaming at the suspect, and attempting to physically wrest a gun from his hands, whereas for Rollis' case, officers engaged in a conversation with Rollis, followed him into a garage at a distance of 6 to 10 feet, and did not yell until after he picked up a hammer. Although those decisions are major setbacks for cases involving split-second decisions, for less time-pressured scenarios, the Supreme Court has begun to pare back qualified immunity. Last term, the High Court overturned two Fifth Circuit rulings that upheld qualified immunity for prison guards who left a man inside cells teeming with human waste and who pepper-sprayed an inmate for no reason. The Supreme Court has long been deferential to law enforcement, especially in split-second decision-making. In response, the House of Representatives has twice passed the George Floyd Justice in Policing Act, which would eliminate qualified immunity for police, but those efforts have failed in the Senate. As a result, it's left to state legislatures to protect everyone's constitutional rights. It is absolutely important for state houses to open up their courthouse doors to individuals with claims against officers, Institute for Justice attorney Anya Bidwell told The Washington Post. The institute has developed model legislation to sue abusive agencies in state court, a bill that inspired a landmark reform enacted in New Mexico this past spring.